The High Court has summoned the embattled Energy and Petroleum Regulatory Authority EPRA Director General Daniel Kiptoo to explain why he disregarded a court order suspending the implementation of the Finance Act 2023 and adjusted fuel prices. 3 High Court judges hearing petitions challenging the provisions of the Act yesterday directed Kiptoo to appear before them on September 13, 2023, as sought by Busia Senator Okiya Omtata.
There was an application by Mr. Omtata for contempt. Summons shall issue to Mr. Bargoria to attend court on 13th of September.
Omtata has accused the EPRA boss of adjusting the fuel prices in line with the Finance Act 2023 against the court order.
The court has ordered that the summons be issued for the CEO of EPRA to appear in court and tell us why he defied the orders of the court. So that's going to happen.
Justices David Majanja, Christine Mioli and Lawrence Mugambi issued the summons, even as they declined to suspend the implementation of the housing levy and backdating of deductions to July 1st as pleaded by the Law Society of Kenya LSK, among other lobby groups.
We are not persuaded that we should exercise this jurisdiction at this stage, in view of the fact that those issues were all before the court when it made the decision. Must be recalled that this is a decision in rem, and it binds all the parties, whether they were before the court or not.
The judges ruled summons are hereby issued to Daniel Kiptoo to appear in court. This is the second indictment against Kiptoo after previous audit by the Auditor General Nancy Gathungu revealed that Kiptoo is unqualified to hold the EPRA Director General's post and that his recruitment was irregular. Gathungu said Kiptoo was confirmed as the DG without the requisite qualifications and therefore his appointment was irregularly done. The report says in part, a review of the applicant's documents confirmed that the person lacked the requisite management experience at senior level for appointment as DG. The regularity and suitability in the appointment of the DG was a breach of law. Gathungu noted that the EPRA board chaired by retired Judge Jackton Ojwang in consultation with the then Energy Cabinet Secretary Charles Keter erred in appointing Kiptoo as the substantive DG on July 1, 2021 after serving in an acting capacity since December 2020. Section 13 of 1 of the Energy Act stipulates that the board shall, subject to the approval of the Cabinet Secretary, appoint a DG who shall be the CEO of the authority. Section 13, number 3, C.D. of the law says a person shall be qualified for appointment as DG if the person has at least 7 years of management experience at a senior level and at least 2 years of experience in petroleum and energy sector. According to the minutes and internal records seen by the Informer Media Group, DG's post was declared vacant on March 31, 2021 and subsequently advertised on April 27, 2021 following the interdiction of Pavel Oimeke over corruption allegations. Consequently, an 83rd special meeting of the board held on May 20, 2021 delegated the tasks of shortlisting of the applicants to the Finance and Administration Committee of the board. In a statement signed by the chairman, retired Justice Jackton Ojwang, the board says Energy and Petroleum Regulatory Authority EPRA Board of Directors, in consultation with the Cabinet Secretary for Energy Charles Keter, has appointed Mr. Daniel Kiptoo to the role of Director General for a term of 3 years, renewable once, with effect from July 1, 2021. The board added that Kiptoo held the position in an acting capacity since December 14, 2020. Kiptoo is said to have been instrumental in drafting the Energy Act 2019 and the Petroleum Act 2019. He previously worked as the legal advisor at the Ministry of Energy and State Department of Petroleum. Our source intimated that since the Auditor General has confirmed the DG's appointment was a nullity and was irregularly done, we now want the Cabinet Secretary for Energy and Petroleum Davis Chirchir to reverse this appointment and ensure the law guiding DG's appointment is followed to the letter. Yesterday, Omtata submitted that the High Court issued an order on June 30, 2023, suspending the implementation of the Finance Act 2023, but EPRA adjusted the prices by doubling the value-added tax VAT charged on the commodity to 16% from 8%. The senator said EPRA hacked the prices of petroleum products in defiance of the conservatory order, even after being served with the court order. Omtata told the court to cure this absurdity and to avoid compromising the public interest in the rule of law and the authority of this honorable court, it is profoundly important that Mr. Daniel Kiptoo Bagoria is punished for contempt according to the law. On the housing levy, the LSK, through its president Eric Theuri, submitted that Treasury Cabinet Secretary Njuguna Ndung'u appointed the Kenya Revenue Authority collection agent against the law because there are no enabling laws giving the taxman such powers.
We pray that first, that there be a conservatory order, that the Section 84 of the Finance Act cannot be implemented.
Theuri further said the KRA has issued a notice to employers and employees notifying them of the decision to backdate the levy to July 1st, 2023. The LSK president said between July 1st and 20th, there was a court order stopping the implementation of the act. The implementation of the housing fund cannot therefore be implemented retroactively as suggested in the notice.
Conservatory order for stay of implementation of Section 10(2) of the Income Tax Act as amended by Section 7 of the Finance Act, a conservatory order to stay the implementation of Section 17(2) of the Value Added Tax as amended by Section 33A of the Finance Act 2023.
He argued that the levy can only be implemented after the Court of Appeal lifted the conservatory order. Theuri said the net effect of the provision of Section 84 of the Finance Act would be to burden taxpayers who will be forced to shoulder an unfair tax burden contrary to the Constitution. The judges, however, declined to block the implementation of the housing levy, saying the Court of Appeal considered all the aspects when it lifted the suspension. The court said in a ruling read by Justice Majanja that although the Court of Appeal stated that the High Court would consider suspending provisions of the Act whose implementations would have an irreversible effect and where funds cannot be refunded, we are not persuaded that we should exercise this jurisdiction at this stage in view of the fact that these issues were all before the court before it made the decision.
By ruling dated 28th of July 2023, the Court of Appeal made an order, that the order made on 10th July 2023, that is the conservatory order, suspending the Finance Act 2023 and the order prohibiting implementation of the Finance Act 2023 be and is hereby lifted pending hearing and determination of the appeal. The effect of this order was to lift the suspension imposed on the law by the conservatory orders issued by the High Court, and whose effect, in our understanding, was to merely suspend that law. Once the Court of Appeal lifted the suspension, it meant that the Finance Act would be implemented. Although the court stated that the court could consider suspending specific provisions of the Act whose implementation would have an irreversible effect and where parties cannot be refunded, we are not persuaded that we should exercise this jurisdiction at this stage in view of the fact that those issues were all before the court when it made the decision.
The LSK argued that the housing levy is discriminatory as it only obligates those in formal employment to contribute to the scheme without a corresponding duty on persons in informal employment to contribute, yet the latter is the target population of the scheme. Further, the LSK said the levy is uncertain in terms of eligibility criteria and administration, making it impossible for the beneficiaries to be known or Kenyans to know the government agency that will administer the fund. The court submitted that Section 84 only provides for remittance of the housing levy by both employer and employee, but there is no body that has been charged with the administration of this levy. If indeed the said levy was to be administered by a particular government agency, then nothing would have been easier than for the legislation to state so. Senate Speaker Amason Kingi, through lawyer Cecil Miller, argued that the Finance Act underwent sufficient public participation and that the Act does not affect the functions and powers of county governments as alleged. Miller said in a response filed in court, in any event, there was a concurrence between the Speaker of the Senate and the Speaker of the National Assembly, confirming that the Finance Bill 2023 did not have provisions affecting the functions and powers of county governments. The court at the same time consolidated all the petitions and directed parties to prepare themselves for hearing on September 13th and 14th, 2023.